what is the penalty for being intentionally homeless? Now, this question came up in the weekly live stream last week, and I thought it's just a really good question. It's also quite a revealing question, because it just kind of makes the point that a lot of people think, a lot of housing officers as well, think of intentional homelessness as being a punishment, as being a punitive measure. And it's not really ever supposed to be that. It's, you know, the whole idea of homeless applications being a moral test about your character, that's not how it was ever supposed to be. I know a lot of housing officers think it is like that, but that's not how it's actually supposed to be legally. The roots of intentional homelessness come from a time when it was quite a lot easier to get social housing, and people realised that if they made themselves homeless and become homeless, they would then kind of jump the waiting list and they get housed more quickly. So the idea of intentional homelessness was brought in to stop people doing that. It wasn't really supposed to, well, it isn't supposed to be there to catch people who have a drink problem and aren't managing their life very well. If you actually look at the code of guidance, people who become homeless in situations where their substance use or their mental health had an impact on their ability to get by probably are not going to be intentionally homeless at all. They'll often be told they will be though, so you know, you've got to watch that. In my experience, most of the people who are told they're intentionally homeless are not intentionally homeless when you actually look at the law. Again, things like rent arrears, you know, that's not necessarily going to make you intentionally homeless. You need to look at the kind of detail of it, and I've done other videos on the channel about that. But the penalty, if that's the right word for it, of being intentionally homeless is that the council won't owe you a long-term duty of housing. So the main housing duty, which is section 193 of the Housing Act 1996, basically applies to people who are homeless. They are eligible for assistance, so they have recourse to public funds. They're in priority needs. Local connection doesn't apply, or kind of they have local connection, let's say, and they're not intentionally homeless. And in that case, the council will need to discharge that duty by an offer of social housing, in effect, or an offer of a 12-month assured short-hold tenancy in the private rented sector in decent quality private rented accommodation in theory. So that's kind of, you know, that's why the main housing duty is kind of the holy grail of the homeless application process. There are lesser housing duties within the relief duty, and again, I've done videos about that elsewhere. So, for example, the final accommodation offer mirrors the main housing duty in that it's an offer of a short-hold tenancy, but it's only 6 months rather than 12 that you get in the main housing duty. Equally, a final Part 6 offer, it mirrors the main housing duty, but I don't think you get as much choice on the housing register. Kind of think of it like that. But if you are intentionally homeless, then those two options won't apply to you. You can still get other options. So just to make the point, and I really can't emphasize this enough, even if you definitely are intentionally homeless, and there aren't many people who definitely are intentionally homeless, you still need to make homeless applications if you're homeless, because if you're in priority needs, there's something called section 190 applies, and that's kind of really the crux of this question here is the difference between section 190 and section 193, the main housing duty. And so the section 190, the section 190 duty applies to people who are homeless, eligible, in priority needs, local connection is taken care of in some way, but they're intentionally homeless, and in that case they'll be accommodated for maybe 4 weeks. It's not really kind of set in stone. Could be as little as 2 weeks, I guess. Could be less, I guess, technically. Could be more. Could be, you know, 2 months, something like that. But the crucial thing to understand is that that duty kicks in at the end of the relief duty. So if you're in priority needs, you'll be in temporary accommodation. Within a few days of making the application, the council should be able to satisfy itself that you are homeless and you are actually eligible for assistance. So that's when the relief duty starts ticking. 56 days later, it should end. And at that point, they can issue that section 190 decision, which is this short-term accommodation option. And it's basically designed there to give you time to find something else. And councils can tell you that they think you are intentionally homeless in that kind of relief duty period, and kind of say, you know what, you know, on this basis we think we are going to find you intentionally homeless. We haven't made that decision yet, but we think you are, therefore you need to factor that into your, you know, your kind of home search or whatever. But that's kind of how it would kind of kick in at the end of it all. And so really that's the penalty in simple terms. If you're not intentionally homeless and in priority needs and homeless and eligible, so on, the council will basically house you in settled, suitable accommodation. You know, it's obviously not as settled in the private rented sector, But if you're intentionally homeless, there's only that short-term duty to apply. And interestingly, so Will Flack, who comes on the live stream with us, he was actually involved in a case recently where basically he challenged the suitability of accommodation given under Section 190. So even though it was only for a few weeks, the council still had a duty to make sure it was suitable. And in that case, the council hadn't made sure that was the case. So that's kind of, something to bear in mind. In terms of how long that period can be, again, I've talked about this elsewhere on the channel, it does depend on the circumstances. You can't have a blanket kind of time span. I know some councils do, they'll say 14 days or whatever, 28 days, but that's not legal. They need to look at the applicant's actual circumstances. But as I say, that's the kind of main difference. And this question came up, and I'll probably say this just to finish off, this question came up because we were talking about someone who had turned down what seemed to be a suitable offer of accommodation, which is not recommended. Out of all the things you can do, turning down any sort of accommodation is a very big risk, and the risk is you end up with nothing. That's what happens if you lose. Which is why anyone with any kind of, anyone who works in the sector will advise you to accept the accommodation, then challenge the suitability of it. But in this case, they'd effectively said they didn't want to move in, and it didn't seem to be for a very kind of good reason, kind of more preference than kind of need, that sort of thing. But there's nothing, the council then ended their duty. So, they kind of had a main housing duty. They provided this offer of accommodation. The applicant turned it down without what seemed to be a good reason. So the council can then say, right, we've ended that duty under the homeless application. But just to make the point, there's nothing stopping you then reapproaching the council to make a fresh application, because although it may well be you're intentionally homeless, it's not set. The council cannot say at that point you're definitely intentionally homeless, because they haven't actually looked into the argument yet. There might be more information that they need to find out, which is why you're saying it was not suitable, which may actually come to light in that subsequent homeless application, because at that point they've really got to work out, was that actually suitable in the first place. So hopefully that kind of gives a bit more information about this kind of idea of what happens if you are intentionally homeless. Bear in mind as well, I haven't said it yet, if you're not in priority need, if you're genuinely not in priority need, it doesn't really make any difference if you're intentionally homeless or not. The council won't have a duty to put a roof over your head anyway. They still do have a duty to go through the relief periods. They do have a duty to kind of take reasonable steps to try and find you accommodation. But that is not the same thing as telling a council to house someone. And if you look at how many councils don't house people when they actually have a duty to, you can kind of infer from that how many people they house when they don't have a duty to house. It's probably, very, very low numbers indeed. But it's still kind of something to be there. So yeah, again, kind of just to summarise the answer to this question, even if you are intentionally homeless, you should still make a homeless application, because whether or not you're intentionally homeless does not actually apply within Section 184. The homeless application itself doesn't mention intentional homelessness, and it doesn't mention it within the Section 188 duty either. So the Section 188 interim accommodation duty, the duty to provide emergency accommodation, applies if there's reasons to believe that you might be homeless, might be eligible, might have a priority need. It does not mention local connection or intentional homelessness. So yeah, again, it's kind of, a lot of councils kind of do that sort of stuff. I've seen LGO decisions before where the council said that from day one. The council had just evicted that person from their own accommodation. They kind of knew from the court process that that person had absolutely acted intentionally, and yet they still couldn't refuse a homeless application, and they could not refuse to provide interim accommodation, because that's how the law works basically. They still had that Section 190 duty to provide accommodation for a short period of time, which in practice these days is going to be about 3 months, give or take. It certainly can't be less than 2 months, let's put it that way. So, or certainly can't be less than 56 days, let's say it that way. That's probably the most accurate way of saying it. So yeah, hopefully that helps. Do check out the online training we do. Do check out the weekly live stream. If you ask a question in the comments section, I will take it to the weekly live stream, either the one on this channel on the Thursday or the one on Will's channel on a Monday. It needs to be coherent without being too long. And just to reiterate, and I know no one listens to me on this, please don't say it's about yourself. Don't say, what if, I'm kind of currently getting evicted by council. Just say, what if someone was being evicted by the council with these circumstances? What would the law do? Is actually a much better way to get a better response, and you don't have to put your personal data all over the internet. So yeah, hopefully see you at a weekly live stream at some point. Take it easy. Bye bye.